भी अपने 6th इशू के लिए सबमिशंस ले रहे हैं ना?
Yeah, कोई
Okay, so very good afternoon and good evening to everyone present here. First of all, I would like to wish everyone a very happy Ganesh Chaturthi and also a big thank you for taking time out for attending this webinar on this auspicious day. So I'm Khyati Tongia. I'm a third year law student working as content manager for Fastforward Justice. I would like to thank Amit sir, who is the founder, CEO, and editor-in-chief of Fastforward Justice, for giving me this opportunity. Fastforward Justice is an online organization which has always aimed at presenting law in its simplest form as to make law accessible even for a layman to understand. It conceptualizes the efforts of law students at all levels and believes in working together for bringing a development in the present legal education system. To achieve this vision, various seminars, workshops, competitions are organized with a focus on drafting and researching skills. The Fast Forward Journal is currently inviting submissions for its 6th issue. For more details, you can check out our post on Law Octopus and also our website. In the end, providing opportunities for development of stakeholders of this field is the mission. And to achieve this mission, today's webinar on rights of accused under police custody is organized. Today's speaker is Advocate Sumitra Chaudhary, ma'am. We welcome you, ma'am. So, giving a brief about a speaker today, I would like to say that she is an advocate practicing at the Supreme Court. She has substantial international exposure and having earned a master's from Canada, and she has also worked for 2 years in corporate role in London. She has been championing the cause of prevention of sexual harassment at workplace and violence against women and children. She believes in making law simple for the common man and strives to make legal awareness reach the last mile of the social strata. She contributes to social causes through her writings, lectures, video awareness camps, and appropriate representation on the global forum. We welcome you, ma'am, and it is a privilege to have you as a speaker today. Now, I would like to welcome all the participants and request them to switch on their cameras, and also that if they have any doubts, they can ask in the chat box. We'll have last 10 minutes for doubt resolutions. Now, to throw more light on the subject, I would like to hand over a discussion to our guest. Ma'am, please.
Thank you, Khyati. Thank you for the wonderful introduction, and thank you to the organizers for organizing a webinar on such an important topic. Thank you to all the participants who've taken out time, especially today. So happy Ganesh Chaturthi to you all. And thank you for participating and attending this webinar. I would want you to be a little more participative and active in asking questions. So as and when you have any question, please type it out in the chat box so that you don't forget it if you keep it till the last.
Excuse me, ma'am. I'm so sorry.
Yes, please tell me.
So sorry for interrupting. Ma'am, if you can make it bilingual so it would be easier for the participants since we have both the students.
Definitely. So I'll try to do it bilingual. So I'll do it both Hindi and English as much as possible. So, and if you have any questions, so make sure that you type it out in the chat box at the very same time when you have a question. We can take it up at the end together. All right. So I'll start with the topic, and that is rights of an accused under custody. So a very important topic in today's context because lately we have seen some incidents where we have seen how police has actually gone over or crossed their powers, abused their powers to such an extent where human rights and our fundamental rights were violated. So basically जहाँ पे भी हमारे संविधान से दिए हुए मूल अधिकार अगर कभी वायलेट होते हैं so as per constitution we have the right to enforce it. Similarly, अगर कोई accused है, so हमारा कानून accused को तब तक innocent मानता है जब तक वो prove नहीं होते कि वो guilty हैं. So till that time, they are an accused and they are having all the rights till they are proved guilty. And that is the reason why their fundamental rights are also in place. What is the importance of safeguarding the rights of an accused under custody, we will see later. So जैसे जैसे हम आगे बढ़ेंगे हम जानेंगे कि क्यों जरूरी है कि अगर कोई accused भी है, अगर किसी का ये कहना है कि भाई उन्होंने क्राइम किया है तो उनको क्यों राइट्स होने चाहिए, तो हम जैसे आगे बढ़ेंगे आप जानेंगे कि क्यों उनके लिए भी राइट्स बहुत जरूरी हैं. So I'll start with a quote that every right is a moral as well as legal entitlement. So rights जो हैं हमारे, it's a moral and legal entitlement. This entitlement is whether we can do something or we cannot do something. So every human is given certain basic rights. For example, right to live, right to freedom. All right. So Constitution of India also. So these rights we are born with. ये हमारे जन्म सिद्ध अधिकार हैं. As in पैदा by virtue of being born, we have those rights. Those rights are enshrined onto us. So हर country के अपने उन rights हैं. Similarly, Constitution of India also provides various provisions which guarantee certain rights. So certain rights to accused are also given in certain circumstances. Okay, so now when we are dealing with the rights to accused and that to someone who's in custody, we will deal with three major articles. So Article 14, Article 21 and Article 22. So remember, if you know these three articles well, a lot of your questions will be answered by these articles. So Article 14, हम सबने सुना है, equality before law and equal protection of law. So कि कानून की नजर में सब बराबर हैं. So that is our Article 14, equality. Article 21, that no person shall be deprived of their life or personal liberty. So Article 21 is basically right to life. Okay, no person shall be deprived of their life or personal liberty except according to procedure established by law. So जब भी आप आर्टिकल कोई भी आर्टिकल या कॉन्स्टिट्यूशन में दिया हुआ हमारे आर्टिकल या फंडामेंटल राइट्स पढ़ें तो प्लीज फोकस उसकी लैंग्वेज पे, उसके हर एक वर्ड पे फोकस कीजिए बिकॉज दोज वर्ड्स से अ लॉट. So when you read in its entirety, you will understand कि what it is trying to say. It is like बहुत मीनिंग छुपा है उसके पीछे. So Article 21 क्या कहता है? No person shall be deprived of their life or personal liberty except according to procedure established by law. अब Article 22. So आज के सेशन में we will deal with three important articles. Article 14, equality before law, right to equality. Article 21, right to life, and Article 22. अब Article 22 क्या कहता है? Article 22 of the Constitution guarantees protection against arrest and detention. So ये article very important for you to know. Article 22 will always be read with Article 21. ठीक है, Article 21 का extension है Article 22. तो आप अगर Article 21 and 22 को entirety में पढ़ेंगे, then you will understand how our Constitution has guaranteed protection against arrest and detention in certain cases. ठीक है? So what this article states? This article says that no person who is arrested shall be detained in custody without being informed. So points note karna, without being informed as soon as may be of the grounds for such arrest, nor shall be denied the right to consult and to be defended by a legal practitioner of his choice. So यहाँ पे तीन चार important बातें उन्होंने एक ही लाइन में कह दी कि कोई भी पर्सन जब अरेस्ट होता है या उनको डिटेन किया जाता है तो बिना इंफॉर्मेशन, मतलब उनको इन्फॉर्म किए बिना कि उनको क्यों अरेस्ट किया जा रहा है, और उनको राइट टू कंसल्ट को डिनाई नहीं करेंगे, और अगर कोई लीगल अगर इफ दे वांट अ लॉयर टू रिप्रेजेंट देम, दैट विल आल्सो नॉट बी डिनाइड टू देम. सो एक सेंटेंस में उन्होंने बहुत सारी बातें बता दी कि क्या आपके राइट्स हैं आर्टिकल 22 के अंदर. आगे इसको हम डिटेल में पढ़ेंगे. दिस वाज जस्ट अ बेसिक आइडिया दैट आई एम गिविंग ऑफ आर्टिकल 14, 21 एंड 22. सो हमारा जो कॉन्स्टिट्यूशन है, as per our constitution, life, liberty and dignity of a person, they are at the core of human rights. और अगर ये चीजें हम प्रोटेक्ट नहीं करेंगे अपने कॉन्स्टिट्यूशन में, तो द लाइफ ऑफ ह्यूमन बीइंग विल बी मिजरेबल देन दैट ऑफ एनिमल्स. सो लाइफ, लिबर्टी एंड डिग्निटी ऑफ अ पर्सन, दे आर द कोर ह्यूमन राइट्स. और हमारे जितने भी ह्यूमन राइट्स हैं, दे ऑल रिवॉल्व अराउंड दिस. सो इन्हीं से डिराइव किए हुए हैं हमारे ह्यूमन राइट्स. Similarly, the penal and the procedural laws which have been enacted, they also have to ensure that life, liberty and dignity of a person are always protected. तो whether हमारा IPC है या हमारा CRPC है, इनके जो प्रोसीजर्स हैं, इनके जो penal laws हैं, इसमें जो भी provisions दिए गए हैं, they also have to protect life, liberty and dignity of a person. All right. So अब ये आईपीसी सीआरपीसी को इम्प्लीमेंट करने वाले जो जुडिशियल ऑफिसर्स हैं, वेदर इट इज लॉ एनफोर्समेंट ऑफिसर्स, प्रोसिक्यूटर्स, एडवोकेट्स, anybody and everybody who is involved in the criminal justice system, they also have to keep all life, liberty and dignity of a person as the core and ensure that this does not get violated at any time. Okay. Now, there are a lot of penal provisions. There is CRPC, there is IPC, but even then, implementing those laws in their stricto sensu meaning is not possible. But then, rights of the accused as well as the victims. So, ऐसा नहीं कि सिर्फ accused के rights, but rights of the accused as well as the victims is the essence of our justice system. And that is what the constitution of democratic countries give to their citizens. So without losing the essence to what our constitution is giving, we must ensure that the rights of both the accused as well as the victims is taken care in a way that किसी के भी rights compromise नहीं हो रहे हो. So like how every country gives certain rights to their citizens, so those rights are absolutely fair without any prejudice. So it is in the spirit of common brotherhood, in the spirit of right to life, right to equality, right to freedom, right to education, right to freedom of religion, so it is in the spirit of common brotherhood. So what the constitution wants is that people live freely with, they have the right to their life and liberty and with dignity also. So again, those same core values are the centerpiece of everything. We will speak about the rights of the person who we believe in guilty prove नहीं होते तब तक आप innocent है. This is the main crux. हमारा legal system इसमें mainly believe कर. Now, any unlawful arrest of an individual is in violation of Article 21. So Article 21 is right to life and liberty. So अगर कोई unlawful arrest होता है बिना किसी reason के या unlawful arrest होता है, तो that arrest violates right to life and liberty. So now let's see what are the rights of an accused person under our constitution. अब इसमें 2-3 stages में हम इसको देखेंगे कि right जब वो arrest होने से पहले, so before trial, rights during trial and rights after the trial. So trial तब commence होती है when the matter reaches the court, and before that is before trial, and during trial is when the matter is pending in the court, and then after trial is after trial. So accused has a right to get fair trial. They have a right to get bail. They have a right to hire a lawyer. They have a right to legal aid in case they cannot afford. So these are few of the rights which I'm sure everybody is well aware of. So as I said, that our criminal system is based on a legal principle which is innocent until proven guilty. So uska jo legal maxim hai, I'll just read it out. So it says A incumbi probatio qui dicit non qui negat. So which translates into the burden of proof is on the one who declares, not on the one who denies. All right. So if I go and complain against somebody, then the burden of proof is on me to prove that the other person has done such a thing. It is not on him to prove that he has not done. So the burden of proof lies on me to prove, not on the other one who denies. Okay. So now let us see what are the rights. So as I said, Article 22, we'll read the Article 22 later. We'll first get into what are the rights. So rights of arrested person in India would be first. So as soon as somebody is coming to arrest a person, you have the right to know the grounds of arrest. Then once you're arrested, you have the right to be produced before a magistrate without unnecessary delay. So everybody knows that 24-hour rule, that within 24 hours you have to be produced before a magistrate. Now, right to be released on bail. So once something has been ascertained, then you have a right to be released on bail. So there are various kinds of bails: default bail, which is also called a statutory bail, then your regular bail, then you have anticipatory bail, then you have transit bail. So right to be released on bail. So against a certain surety, you have a right to get released. Then there's a right to fair and just trial. You have a right to consult a lawyer. You have a right to free legal aid. You have a right to silence. So we will speak about all this in detail later. You have a right to be examined by doctor, and then obviously the right to appeal against any decision. There's a right to humane treatment in prison. There's a right to have family visits in jail, and you have a right against solitary confinement. So these are basically few important ones that I felt, that are very important to. So I collated this that we'll speak about these rights in detail. Now, talking about Article 22, as I said that we'll speak about Article 22. I will just refer to the Constitution and what it says exactly verbatim. So, Article 22 says protection against arrest and detention in certain cases. All right. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, nor shall he be denied the right to consult and to be defended by legal practitioner of his choice. Okay, so very clearly, the very first clause says that any person who is being detained or taken into custody shall be informed about the grounds of arrest. तो उनको बताना जरूरी है कि उनको किस ग्राउंड पे अरेस्ट किया जा रहा है. देन उनको राइट टू कंसल्ट है, सो वो अपने लॉयर से बात कर सकते हैं या वो अपने लॉयर से डिफेंड होने की बात कर सकते हैं कि मुझे अपने लॉयर से बात करनी है और मेरा लॉयर मेरा केस डिफेंड करेगा. तो ये राइट उनको है. आर्टिकल 22 सब क्लॉज 1 बहुत क्लियरली इस बात को कह रहा है. ठीक है. नाउ वी गो टू सब क्लॉज 2 व्हिच सेज every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of the magistrate. सो आपके आर्टिकल 22 सब क्लॉज 2 ने बहुत क्लियरली ये बता दिया है कि एनी पर्सन जो भी किसी को भी अरेस्ट किया गया है या डिटेन किया गया है, कस्टडी में लिया गया है, उसको सबसे नियरेस्ट मजिस्ट्रेट जो है उनके पास विद इन 24 आवर्स में प्रोड्यूस करना मैंडेटरी है, बहुत जरूरी है. इन 24 आवर्स में वो टाइम कैलकुलेट नहीं किया जाएगा जो एक जगह से उस प्लेस जो प्लेस ऑफ अरेस्ट है वहां लाने के लिए जो जर्नी अंडरटेक करनी है. सो अगर जैसे 1 या 2 घंटे की दूरी पे हैं तो वो 2 घंटे उसमें कैलकुलेट नहीं होंगे, 24 आवर्स में ऐड नहीं होंगे जो जर्नी के लिए जरूरी है. इज दैट क्लियर? Now, other than these also, there are few more provisions in Article 22. So Article 22 has almost 7 clauses. जो first three clauses हैं, they speak about regular regular detention or custody, और जो बाकी के clause number 4 to 7 है, they speak about preventive detention. Okay, so what is preventive detention? Preventive detention means detention of a person without a trial in such a circumstance that there is not much evidence to say that उसके ऊपर चार्ज लगाया जा सकता है, but उसको डिटेन करना इसलिए जरूरी है क्योंकि अगर डिटेन नहीं किया तो there is a possibility of a very grave situation arising out of it. So that is preventive detention. कई बार preventive detention you guys must have, I don't know, since you are all students, I am not sure if you heard about 107 116 की प्रक्रिया. So 107 116 is पावन करना किसी को, right? So that is like preventive. It's a preventive step. आप किसी को stop करते हैं that they should not do a certain thing, and if they are found doing something within this time period, then they will be arrested directly. All right. So similarly, preventive detention is something that will stop. It's a preventive step. कि कोई जुर्म हो ना जाए उससे पहले आपने उनको डिटेन कर दिया so that it does not occur. So to stop that, it's a preventive kind of a step. So the object of a preventive detention is to prevent a person from doing something. So no offense. There might be that there is no offense that has happened, or they do not have any proof, या फिर they cannot formulate a charge on a person, but there is reasonable suspicion. There is a probability. All right. So preventive detention is not a criminal conviction, but it is to ensure that a certain thing does not occur. Okay. Now, what was the objective of the framers of Constitution? To give preventive detention so much importance. So they wanted to provide safeguards to prevent any abuse of power. So the procedural requirement are mandatory, and any violation makes the detention invalid. Okay. Talking about presumption of innocence. So again, even Blackstone, he's very famous in our legal world. So Blackstone's famous word also says that it is better that 10 guilty persons escape, but that one innocent suffers. So nobody should suffer who is an innocent person. And that is why our system also presumes a person to be innocent till a charge is proven against them without any reasonable doubt. So that is the essence of a criminal trial. The essence of a criminal trial is that the accused is to be presumed innocent until proved guilty beyond a reasonable doubt. So guilty भी ऐसे नहीं कि हाँ वो guilty prove हो रहा है, but beyond a reasonable doubt, वो doubts के दायरे से बाहर निकल के ये होना चाहिए कि हाँ वो guilty है, and that is when he is taken as a person who's guilty. Now, let us look at pre-trial rights of an accused in India. So, as we discussed that there are pre-trial rights, there are rights during the trial, and there are rights after the trial. So, the rights of a person who's accused of a crime, their freedom and liberty should not get hampered. So, since the first stage of the trial, the pre-trial stage is where a FIR is filed or FIR is registered, on the basis of which the person will probably arrest a person or searches his or her property. So at this stage, what are the rights? At this stage, the accused has a right to know about the accusation and charges. So two books that you should be really thorough with. One is Constitution of India and the other is CRPC. So make sure that you have your CRPC with you and your Constitution of India to know about the rights. So whenever it comes to a citizen, a person's rights, fundamental rights, it is the Constitution. And about anything to do with the police and their procedure and the procedure adopted by them and what rights you have, then go to CRPC. So under CRPC 1973, the rights of an arrested person under CRPC includes to know the details of the offense and the charges filed against him or her. So they have the right to know about कि उनके ऊपर क्या इल्जाम लगा है about the accusation और क्या charges हैं. Now, another right, that is pre-trial right, is right against wrongful arrest. Okay, so rights of an accused in India are provided only in cases where a warrant is issued. So अगर warrant issue नहीं हुआ है तो section 57 of CRPC and article 22 sub clause 2 say of the constitution says that rights of an accused in says that a person who's probably detained or has been arrested without any warrant must be produced before a judicial magistrate within 24 hours of arrest. ये क्यों जरूरी है? Because within 24 hours if you're produced before the magistrate, it is a responsibility and duty of the magistrate to ensure that whether the detention is legal or illegal, or is it required, or is it unnecessary. So there you have another check where the constitution has provided another check to ensure that your life and liberty is not being transgressed. Then the accused has a right to privacy and protection against unlawful search. So you know that a search cannot be made on a mere presumption of an offense. So if somebody wants to search, then they need to have a proper search warrant in place. Okay, so the police officials cannot violate the privacy of the accused. There is an offense that is going to happen, or there is something like this over here, they have to produce a search warrant. So as per the rights of accused, his or her property cannot be searched by police without a search warrant. Incrimination. So a person against himself, तो मुझे अपने खिलाफ स्टेटमेंट देने के लिए कोई फोर्स नहीं कर सकते. ये हमारा आर्टिकल 20 Indian Constitution be compelled to be a witness against himself. So nobody can force me to give a statement against myself, और वो valid भी नहीं होगा. Then the person has a right against double jeopardy. Now what is double jeopardy? Double jeopardy means कि एक ही ऑफेंस के लिए आपको एक से ज्यादा बार सजा नहीं मिल सकती. तो अगर एक गलती की है तो एक गलती की एक बार सजा मिल सकती है, बट उससे ज्यादा आपको मतलब second time सजा नहीं मिल सकती. So a person cannot be prosecuted and punished for the same offense more than once. So this is again protected, given in Article 20, subclause 2. Now there's another right that a person has, and that is the right against ex post facto law. Now what is ex post facto law? So if there is a crime that was committed by a person, okay? It was a crime, but now it is not a crime, then the person cannot be tried for an offense. All right. So a person has an authority where he cannot be tried for an offense which was earlier a crime, but now it is not. So criminal law में retrospective effect से ये law applicable नहीं होगा. An act that was not a crime on the day it was done cannot be considered as a crime now. Okay. So जैसे एक certain date से पहले एक चीज क्राइम नहीं थी, लेकिन उस टाइम पे उन्होंने वो गलती अगर करी थी तो आज की डेट में लाके उसको ऑफेंस नहीं माना जा सकता. ठीक है. Now bail as a right of accused in India, of course. So you have right to bail. जब एक बार डिटेन कर दिया है तो आपके पास, या फिर इवन डिटेंशन से पहले, एंटिसिपेटरी बेल, interim bail, default bail, statutory bail, regular bail. So all these kinds of bails are a right which an accused can apply for. Then there is right to legal aid. So ये state की जिम्मेदारी है. Again, it's the responsibility of the state to provide legal aid. अगर किसी के पास कोई afford नहीं कर सकता lawyer को, तो state must provide free legal aid for their representation in the court. Then there is right to free and speedy trial. वो तो हर किसी का right है, so accused also has that right to free and speedy trial basically. So without any bias or prejudice, a fair trial and a speedy trial. Now let us look at rights of the accused during the trial. Okay. So मान लिया कि किसी को अरेस्ट कर लिया गया है and then after that जो इन्वेस्टिगेशन है वो हो रहा है, चार्जशीट प्रेजेंट हो गई. So what are the rights during a trial? So right to get copies of the documents. So the person has a right, अगर उनके अगेंस्ट चार्जशीट फाइल हुई है तो उनको चार्जशीट की कॉपी मिलनी चाहिए, ये अक्यूज्ड का राइट है. Then right to be considered innocent until proven guilty. So that we already discussed that till the time a person, on the basis of evidence, statements, witnesses, जब तक कि वो complete नहीं होता procedure और वो prove नहीं होते guilty, तब तक उनको innocent presume करके चलना, that is also a right. Right to be present at a trial, obviously they have the right and they have the mandatory, it is mandatory also. So criminal trials में, unlike civil trials, criminal trial में the accused and the complainant, they most of the time have to be present in the court. So उनके presence में ही trial होती है. In civil trial, it is not like that. We don't have to, it's not mandatory that we take our clients to the court every single time. It is up to the client. If they wish to come, if they want to come, they can definitely come. But in criminal trial, it is important. All right. Then right to cross examination, that is subject matter of the trial. So trial के दौरान जो सारे rights उनके होते हैं, they are intact as it is. मतलब right to be represented by a lawyer, right to getting their statement recorded, cross examination, dignity, मतलब not to be उनके कोर्ट रूम में भी कि उनको मतलब गंदी तरीके से डिग्रेड करते हुए बात करना, even that is not allowed. So they have those rights which a normal person would have in a trial. Now post trial rights of the accused person. So what if the person is declared innocent after a trial? Then what are the rights of a person? So when a person is declared innocent and acquitted by the court, then he has a right, first of all, to get a copy of the judgment, and then right to receive any protection from police if he thinks that there is a threat to his life after the acquittal. He also has the right to get compensation. All right, so they have the right to get compensation if in case it was a wrong conviction. It was a wrong trial, as in, he was innocent, but even then they were being tried. I will now speak to you about the rights that we said in detail, as in what are the provisions of those rights. So the right to know the grounds of arrest, if you want to make a note, then Article 22 has the provisions for right to know the grounds of arrest. It clearly says that no police official can arrest any individual without informing the accused the reason or ground of his detainment or arrest. Then you have section 50 of CRPC, which says that every police official with the authority to arrest someone without a warrant must inform the person getting arrested about the crime for which he is arrested and other relevant grounds for the arrest. So this is also a duty of the police official which they cannot refuse. So it is a duty of the police official to ensure that they are informing the accused of what are the grounds for which they are being detained. Again, the same section, it also makes it compulsory for the police official arresting a person to inform of the arrest to any of the relatives or friends who may have interest in the matter. So पुलिस की ये भी जिम्मेदारी मतलब कंपलसरी है उनको ये बताना, या तो जिनको वो अरेस्ट करना है उनके किसी रिलेटिव को या फ्रेंड को कि वो उनको अरेस्ट करके ले जा रहे हैं. ओके, अगेन सेक्शन 55 ऑफ सीआरपीसी, it states that in situation where a police officer authorizes his junior to arrest a person without a warrant. अब ये सारी बात हम कर रहे हैं without a warrant वाले cases में. The junior official must notify the arrested person of the order of delegation that is given, which must also mention the crime and the grounds of arrest. तो अगर उन्होंने अपने किसी जूनियर को डेलीगेट किया था ये काम, तो जूनियर की भी ड्यूटी बनती है कि वो आगे बताएं कि उनके क्या ग्राउंड्स पे ये अरेस्ट की जा रही है. Then section 75 of CRPC, it states that police official executing the warrant must notify the substance to the arrested person and finish the warrant of arrest when required. ठीक है, ये warrant arrest warrant से related है. Then right to be produced before the magistrate without unnecessary delay. So हमने जैसे बताया था, एक तो आपको arrest अगर कर रहे हैं तो arrest के time पे ये जानने का right है कि क्या ग्राउंड्स हैं और क्या चार्जेस हैं जिसके लिए आपको अरेस्ट किया जा रहा है. दूसरा, आपको यू हैव the right to be produced before the magistrate without any unnecessary delay. So Article 22 again. So it is Article 22, Section 55 of CRPC, Section 75, 76 of CRPC. So basically it will only be Indian Constitution and CRPC that we are talking about. Article 22(2) जो हमने पहले भी पढ़ा था, which clearly stated that a police official making an arrest without a warrant, he must produce the person arrested without any unnecessary delay before the magistrate with jurisdiction. So जो nearest magistrate है उनके सामने 24 hours के अंदर उनको present करना जरूरी होता है. Again, Section 76 of CRPC also says that arrested person must be produced in court within 24 hours of his arrest. The same must exclude the time duration जो हमने पहले भी discuss किया. Now, so first one is right to know the grounds for being arrested. Second one is right to be right to be taken before a magistrate. Then right to be released on bail. So right to be released on bail depends on what situation you are in, as in, whether you qualify for anticipatory bail or you qualify for statutory bail or you qualify for the regular bail. You have a right to get released on bail by making certain arrangements for the surety. And this should also be informed by the police officer when they are getting arrested. All right. Then you have the right to be to a fair and just trial. So obviously, Indian Constitution, a lot of judgments of the Supreme Court and High Court, they all state that the accused has a right to free, fair, and just trial. So where Article 14 of Indian Constitution says that every individual is equal before law, which means that he has a right to fair and just trial. So even in this case or in any case for that matter, it is important to follow the principles of natural justice for both the parties. So principle of natural justice is not for a single party, only victim, but for accused also. So you must have read already that principles of natural justice has two basic principles. One is audi altrum partem, so which is you have to hear both the sides before taking any decision, and the other one is that no person can be a judge in their own cause. So no person can judge their own cause. So these two principles of natural justice ensure that there is a free, fair, and just trial. So till the time I don't hear both the parties, I cannot probably find out what the truth is. So if I take a decision based on hearing one party, that will definitely be biased and it can be prejudiced. So that is why it is important to hear both the parties before a decision is taken. And it is important that no person is a judge in their own cause, because if they are a judge in their own cause, high chances are that they may be biased. So that is why these are the principles of natural justice. So similarly, there is a right to speedy trial. So that has been upheld in many cases where a person has a right to speedy trial. The main case in that, the landmark case is Hussain Ara Khatun case. Then Right to consult a lawyer. So Article 22 provision, Article 22 clause 1 clearly says that any person who has been who has been arrested has the right to be defended by a legal practitioner of his choice. So they have a right to consult a lawyer. Similarly, Section 41D of CRPC, it allows prisoners to be able to consult with their lawyers even during their interrogation. All right, even when their interrogation is going on, it allows them to consult with their lawyer. Similarly, uh, Section 303 of CRPC, it allows every accused or convict or criminal the right to be defended by a lawyer of his own choice. So a lot of times, even though public prosecutors are assigned, even then वो अपने lawyer के लिए application move कर सकते हैं. They can have their own their lawyer, okay, a lawyer of their choice. Now, the right to free legal aid. So, this is given in Article 39A, where it is clearly mandated that government, in its effort to secure justice, should ensure that free legal aid is provided to people in need. So, those who are in need must have the provision of free legal aid. Okay, so this has also been upheld in many cases, and it has been said that the state must provide free legal aid to the poverty stricken accused person. So, if somebody is so justice should be available to everybody. सो ऐसा नहीं कि जस्टिस गरीबों के लिए नहीं हो, जस्टिस हर किसी के लिए अवेलेबल होना बहुत जरूरी है. और इसीलिए स्टेट्स को, स्टेट मतलब सरकार मतलब गवर्नमेंट, सो ये मैंडेट किया गया है कि गवर्नमेंट की जिम्मेदारी बनती है कि आप फ्री लीगल एड प्रोवाइड करें फॉर दोज पीपल हु आर इन नीड. ओके, एम आई ऑडिबल?
Yes, ma'am, you are.
Okay, there was some disturbance, so I was not sure. Okay. So the right to free legal aid cannot be refused, even if the accused.
I'm so sorry for the pause that we have in between the webinar. I think ma'am is going to join back. There are some network issues, so please bear with us. She'll be back in a moment. We are so sorry for the disturbance, but I think there's some network issues definitely. So by the time ma'am is joining, so I would like to ask, how do you feel? I think ma'am is back. Yes, ma'am. Ma'am, your mic is mute. Ma'am, it's muted. You, yes.
Okay. I'm so sorry about the signal problems today. The network has particularly been like this today. So I apologize for this break. And moving forward, so we were talking about right to free legal aid. So as we discussed already, that every accused has a right to uh, have a legal aid. I mean, if somebody is poor or somebody cannot afford a lawyer, it does not mean that they will not be represented. It is the responsibility of the state to ensure that they are represented appropriately. Okay. Right to be silenced or the right to keep quiet. Very important. This right has not been expressly provided anywhere, so it is not mentioned or written expressly. But if you read through the provisions, it is implied. So it can be derived from CRPC or from the Indian Evidence Act. But the right to silence or the right to keep quiet is also a right that the accused has. So it is basically that any statement or confession made by the accused in the court. So whether they want to remain silent or they want to confess to it or they want to, because once a statement is given to the magistrate, it is important for the magistrate to ascertain whether it was voluntary or whether it was by use of force or manipulation. So they should be free to give their statement. I mean, they should not give their statement under any kind of a pressure or force, and that is why they also have a right to keep quiet. So if they want to keep quiet, they can do that also. Article 20 of the Constitution, again, subclause 2, it says that no person, whether accused or not, cannot be compelled to be a witness against himself. As we already spoke, that nobody can ask me to make a statement against myself or nobody can force me against. This is called principle of self incrimination. So आप मुझे force नहीं कर सकते कि मैं अपने against कोई statement दूं. And this principle has been affirmed in many cases. So that's why the courts have observed that no person can force any other person to furnish any statement or compel to answer any question, because the accused person has a right to keep quiet during his interrogation. All right. Then another important right, and that is a right to be examined by a doctor. So recently there was a case that had happened in Tamil Nadu, wherein this was during the corona, and I think there was a lot of uproar about it and a lot of campaign for justice, wherein the accused, so-called accused, were arrested and they were physically tortured to an extent, to such an extent that they were not in a situation to even stand properly. But because of the corona crisis, they were presented before the magistrate through video, and there were certain lapses there wherein it could not be ascertained what kind of trauma or torture they had gone through, and eventually the accused died in custody. And later on it was found that there was a lot of physical torture that they had to undergo, and in police custody they were beaten up really bad. And it does happen very normally in India, although nobody has a right to torture physically, as in it is not given anywhere in the laws, but it is through a lot of judgments it has been prescribed, it has been set as a precedent, but that is not followed. It is not written in the law that you can physically torture them. Neither it is not written that you cannot do that. So again, that becomes a subject matter of amendment. Again, we need a lot of changes in the law, because such a practice is derogatory to human values and obviously human rights. But then that said, we had this incident that happened, and in CRPC, there is a provision where arrested person can claim for a medical examination of their body. So, if that medical examination would have done, then it would have definitely disclosed the evidence of commission of torture or physical, so they can claim, they can request for a medical examination by a doctor. So the accused also have this kind of a right, that right to be examined by a doctor. So when they are produced before the magistrate, they can definitely ask for a examination by the doctor. So that is another right that the accused must be aware of. Then obviously there are other rights where CRPC clearly mandates that maintaining reasonable health care and safety of every arrested person is the responsibility of the police official who has the custody of the accused. Other than this, there are principles of humane, proper treatment in the prison. So, arrested people normally go through a lot of cruel and inhuman treatment in prison. So, to ensure that that is not happening, Section 55A of CRPC has been there, which says that you have to maintain reasonable healthcare and safety of every arrested person. But then that is not happening. That's another thing, that we have laws, but it has not been followed. Then another person is another section is Section 358 of CRPC, which is a great step towards the principles of natural justice, where it says that arrested person should be provided with compensation when arrested unreasonably. So if it is found that he was arrested unreasonably, then there should be a provision of compensation for such a person. Then other than this, now we'll look at some judicial pronouncements, as in those cases what the courts had said, and whether our police force is following that or not. So two very important case laws that I will look into. One is Joginder Kumar versus State of UP, and the other one is DK Basu, which everybody has heard of. So in Joginder Kumar versus State of UP, what the Honorable Supreme Court has held is that in order to have transparency in the accused and police relationship, the Supreme Court held that right of arrested persons upon request to have someone informed about his arrest and right to consult privately with lawyer are inherent in Article 21 and 22 of the Constitution. So again, Supreme Court upheld the validity of Article 21 and 22, saying that the accused has a right to inform somebody who is known to them about their arrest, and also to consult the lawyer privately. So if the police says that no, even if you're talking to a lawyer, I'll stand here and listen to what you're talking, then he can oppose that and say that I have a right to talk to my lawyer privately. Okay, so that is one right the accused has, as per this case. And the Supreme Court has also observed that no arrest can be made because it was lawful for the police officer to do so. So police officer has a lot of rights when it comes to the rights of police officer under section 41 of CRPC. They are given with a lot of rights, and it is not that just because they have the right, just because they have a power, they will go and arrest anybody. So there should be a justification. Whenever you exercise a certain right or power, there should be a justification for exercising the same. So the Honorable Supreme Court said that the police officer must be able to justify the arrest. So खाली गिरफ्तार करना एक बात होती है, लेकिन गिरफ्तारी के लिए justification, उसका reason होना बहुत जरूरी है. तो ऑनरेबल सुप्रीम कोर्ट ने यही कहा है दैट एनी टाइम एनीबडी इज अरेस्टेड, पुलिस ऑफिसर के पास एक जस्टिफिकेशन होना चाहिए कि क्यों उनको अरेस्ट किया गया. जस्ट बिकॉज उनके पास पावर है तो वो हर किसी को अरेस्ट करके लॉकअप में नहीं डाल सकते, बिकॉज जब भी एक पर्सन को अरेस्ट करके लॉकअप में डाला जाता है तो देयर इज अ लॉट ऑफ हार्म टू देयर रेपुटेशन एंड सेल्फ एस्टीम. सो एक इंसान, एक ह्यूमन बीइंग के रेपुटेशन और नाम और जो उनकी रिस्पेक्ट है समाज में, उसको बहुत बड़ा धक्का लगता है. And that's why it is important that you should have a proper justification, a reasonable justification, that if you have gone and arrested somebody, there should be something genuine and bona fide reason for it. ठीक है, और वो रीजन मतलब ऐसा नहीं है कि आप ना किसी को भी जाके अरेस्ट कर लोगे और उनको लॉकअप में डाल दोगे. सो टू प्रोटेक्ट our fundamental rights, our right to life and liberty, our right to preventive detention, ये आर्टिकल्स में डाला गया है और सुप्रीम कोर्ट ने कई बार इस चीज को अपहेल्ड भी किया है. नाउ उन्होंने कुछ रिक्वायरमेंट्स, इसी केस में उन्होंने कुछ और रिक्वायरमेंट्स भी बताई थी ऑनरेबल सुप्रीम कोर्ट ने. सो फर्स्ट इज दैट एन अरेस्टेड पर्सन बीइंग हेल्ड इन कस्टडी इज एंटाइटल्ड if he requests to have one friend, relative or another person who is known to him or likely to take an interest in his welfare to be informed where he has been arrested and where he is being detained. तो वो अपने किसी जान पहचान वाले को, फैमिली को या फ्रेंड को बता सकते हैं कि उनको अरेस्ट करके कहाँ ले जाया जा रहा है या कहाँ डिटेन किया जा रहा है, ये बताना जरूरी है. दूसरा, द पुलिस ऑफिसर शैल इन्फॉर्म द अरेस्टेड पर्सन when he is brought to the police station of this right. So another thing, there should be an entry made in the diary and मतलब उस एंट्री में ये लिखा जाना चाहिए कि पुलिस ने किसको इन्फॉर्म किया कि सो एंड सो पर्सन को अरेस्ट किया गया है. तो द पर्सन हैज अ राइट कि उनके किसी फैमिली मेंबर को या रिलेटिव को या किसी को इन्फॉर्मेशन जाए कि भाई उनको अरेस्ट किया गया है, अरेस्ट करके कहाँ ले जाया जा रहा है, और पुलिस स्टेशन की डायरी में भी लिखा हुआ होना चाहिए कि उन्होंने किसको बताया था कि उनको अरेस्ट किया जा रहा है. अब हम देखेंगे डीके बसु वर्सेस स्टेट ऑफ वेस्ट बंगाल में कुछ जो गाइडलाइंस जारी करी थी, कुछ प्रिवेंटिव मेजर्स बताए थे ऑनरेबल सुप्रीम कोर्ट ने, वो क्या है. सो बिकॉज ऑफ दीज फ्रीक्वेंट इंस्टेंसेस ऑफ पुलिस एट्रोसिटीज एंड कस्टोडियल डेथ्स, तो सुप्रीम कोर्ट ने अपने काफी सारे डिसीजंस को रिव्यू करते हुए कुछ रिक्वायरमेंट्स बताई थी जो होना बहुत जरूरी है फॉर एनी अरेस्ट और डिटेंशन इन ऑल केसेस ऑफ अरेस्ट एंड डिटेंशन. तो उन्होंने क्या बताया था? फर्स्ट, द पुलिस पर्सनल कैरिंग आउट द अरेस्ट एंड हैंडलिंग द इंटरोगेशन ऑफ द अरेस्टी should have clear visible identification name tags with their designation. तो जो भी पुलिस ऑफिसर अरेस्ट करने के लिए आ रहे हैं उनका नाम और जो बैच है वो बहुत क्लियरली दिखना चाहिए. और इस पुलिस पर्सनल जो भी आए थे उनका रिकॉर्ड रजिस्टर में होना चाहिए, कौन उनका इंट्रोगेशन हैंडल कर रहा है. द पुलिस ऑफिसर carrying out the arrest and arrestee shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one witness who may be either a member of the family or a respectable person of the locality from where the arrest is made. तो जब पुलिस ऑफिसर अरेस्ट करने के लिए आते हैं तो उनको मेमो ऑफ अरेस्ट बनाना पड़ता है और उस मेमो ऑफ अरेस्ट पे सिग्नेचर होने चाहिए एक विटनेस के. वो विटनेस कौन हो सकता है? आइदर तो वो फैमिली मेंबर हो या फिर उसी लोकेलिटी के कोई रेस्पेक्टेबल पर्सन के सिग्नेचर उनको एज अ विटनेस लेना पड़ेगा, और उसमें टाइम एंड डेट ऑफ अरेस्ट लिखना बहुत जरूरी है. सो जो साइन करेंगे विटनेस, वहां पे टाइम एंड डेट लिखना बहुत जरूरी है कि किस टाइम पे अरेस्ट किया और कहाँ से अरेस्ट किया. Now, a person who has been arrested or detained and is being held in custody in a police station or interrogation center or another lockup shall be entitled to have one friend or relative or other person known to him or having interest in his welfare being informed as soon as practicable that he has been arrested and is being detained in a particular place, unless the attesting witness of the memo of arrest is himself such a friend. So, अब जरूरी नहीं कि जिन्होंने विटनेस बन के सिग्नेचर किया था उनको मतलब ही इज अ पर्सन हु गेट्स टू नो कि उनको कहाँ ले जा रहे हैं या कहाँ कौन से पुलिस स्टेशन में रखा जाएगा या कहाँ पे इंट्रोगेशन करेंगे. उसके सिवाय भी किसी और रिलेटिव को, फैमिली मेंबर को या पर्सन को इन्फॉर्म किया जा सकता है कि उनको कहाँ डिटेन करेंगे और कहाँ उनका इंट्रोगेशन करेंगे. ये भी राइट है. The time, place of arrest and venue of custody of an arrestee must be notified by the police where the next friend or relative of the arrestee lives outside the district or town through the legal aid organization of the. ठीक है, ये तो उनको notify करना जरूरी है. Again, it is all about information. The person arrested must be made aware of his rights. So पुलिस को जो जिन person को arrest किया है उनको उनके rights बताना जरूरी है कि उनके क्या क्या rights हैं. अब जब वो ले जाते हैं उनको प्लेस ऑफ डिटेंशन पे, तो वहां पे एक डायरी होती है, उस डायरी में भी उनको एंट्री मार्क करनी पड़ती है कि वो किसको कितने बजे क्या टाइम पे डिटेन कर रहे हैं और किसको इन्फॉर्म किया है। तो जिसको इन्फॉर्म किया है उनके नेम और पर्टिकुलर्स लिखना भी जरूरी है कि उन्होंने फैमिली में या फ्रेंड्स में या रिलेटिव्स में किन को इन्फॉर्म किया। The arrestee should, where he so request, be also examined at the time of his arrest of major or minor injuries, जो हमने बोला था कि right to be examined by a doctor। तो अगर arrestee कहते हैं, मतलब जो accused हैं जिनको arrest किया जा रहा है, अगर वो कहते हैं कि इस टाइम पे आप रिकॉर्ड करो, तो जो इंस्पेक्शन मेमो है उसमें ये चीजें रिकॉर्ड होंगी कि उनके क्या मेजर और माइनर इंजरीज थी बॉडी पे जिस टाइम पे उनको डिटेन किया गया, और इसकी एक कॉपी भी प्रोवाइड करना जरूरी है अरेस्टी को, अक्यूज्ड को। नाउ the accused should be subject to medical examination by a trained doctor every 48 hours during his detention in custody। So हर every 48 hours, that is every 2 days, उनका डॉक्टर से मेडिकल एग्जामिनेशन होना जरूरी है। Why is this important? Why this was put in? ये कस्टोडियल टॉर्चर को, जो फिजिकल टॉर्चर होता है कस्टडी में, उससे सेफ गार्ड करने के लिए इस प्रोविजन को डाला गया है। बिकॉज जो भी पैनल के डॉक्टर होते हैं, दे हैव टू इंश्योर दैट दे चेक एवरी 48 आवर्स एंड उसकी एक रिपोर्ट जाती है कि अगर जैसे फर्स्ट डे पे ये इंजरीज थे उनके बॉडी पे, सेकेंड डे पे मतलब 2 डेज के बाद जब वापस चेक किया तो या तो वो इंजरीज खत्म हो गई या कम हो गई, या फिर अगर और कोई एडिशनल उसमें ऐड हो गई। So that is a way to ensure that उनके साथ custodial torture तो नहीं हो रहा है। Now copies of all documents including the memo of arrest should be sent to जो भी nearest magistrate हैं उनके record के लिए, right? Then the accused has a right to meet his lawyer during interrogation, ठीक है? ड्यूरिंग इंट्रोगेशन का मतलब ये नहीं कि थ्रू आउट इंट्रोगेशन उनके लॉयर वहां रहेंगे, हो सकता है कि वो थ्रू आउट इंट्रोगेशन ना अलाउ करें। Then a police control room should be provided at all districts and state headquarters where information regarding the arrest and place of custody of the arrestee shall be communicated by the officer causing the arrest within 12 hours of effecting the arrest. And the police control room, it should be displayed on a conspicuous notice board. So पुलिस ऑफिसर को पुलिस कंट्रोल रूम में भी इंफॉर्मेशन देना जरूरी है कि उन्होंने किसको अरेस्ट किया है, मतलब every 12 hours ये इंफॉर्मेशन जाती है। The court emphasized that failure to comply with the said requirements shall, apart from rendering the concerned officer liable for departmental action, will also render him liable for punishment of contempt of court. So कोर्ट ने ये भी कहा कि अगर ये जो गाइडलाइंस उन्होंने मेंशन करी थी डीके बासु केस में, अगर ये पुलिस ऑफिसर नहीं फॉलो करते हैं तो डिपार्टमेंटल एक्शन जो होता है वो तो होगा, डिसिप्लिनरी एक्शन, डिपार्टमेंटल एक्शन, but other than that he is also liable to be punished for contempt of court because ये एक court order है, and if they don't follow it then obviously they are committing a contempt of court and they should be liable for an action. So the way we have seen article 20, the requirements in article 21, the article 22, it clearly states how, you know, constitutional and statutory safeguards have been given by the court from time to time regarding safeguarding the rights and dignity of an accused. So there was another important case. You guys must remember, हम पहले movies में देखते थे that people had हथकड़ियाँ in their hands, and then after a certain time now we don't see any prisoners or arrested people having हथकड़ी. They are just you know hand से इस तरह से उनको होल्ड किया जाता है, बट उनको हथकड़ियाँ नहीं लगाई जाती. So this is because of a famous case of Prem Shukla versus Delhi administration. In this, the court observed, this is a landmark case, the court observed that the prisoners or arrested persons have the right not to be handcuffed unless and until some extraordinary circumstances arise during the arrest or when in custody. So अगर unless and until ऐसा कोई behavior उनका हुआ हो या ऐसा कोई incident हुआ हो जहाँ पे ये लगा हो कि he can be so threatening that handcuffing is very essential, तब तक उनको shackles में या handcuffing नहीं करेंगे. So we as a country definitely face huge problems of illegal arrest, and a lot of custodial deaths that happen. Whichever state you want to see, you will find loads of example of custodial deaths. So Article 21, which is very much derived from the Universal Declaration of Human Rights, we to which we are a signatory. Um, Many cases we have IPC, CRPC, Constitution. We have many safeguards. Even then, I think it is imminent that there are some changes to the criminal justice administration, and there are some reforms in the police act, in the police department. Initially, probably when the police department was established, their reason for coming into existence was something else, and that was during the British era. At that time, it was very important to keep everybody scared and uh, threatened by the law system, that if they do anything, the police, मतलब पुलिस का डर होना बहुत जरूरी था. तो उस टाइम पे ऐसा सिचुएशन क्रिएट करने के लिए पुलिस को बहुत सारी पावर्स दी गई थी. बट इंडिपेंडेंस के बाद भी कोई मेजर चेंजेस आए नहीं. एंड हम सब ने देखा है कि पुलिस का बिहेवियर कैसा होता है. सो इवन इफ अ वेरी एनी पर्सन, सी डिग्निटी ऑफ एवरी ह्यूमन बीइंग इज द सेम. कोई बहुत पैसे वाला हो या कोई बहुत पढ़ा लिखा हो, उससे किसी की डिग्निटी कम या ज्यादा नहीं होती है. हर ह्यूमन बीइंग की डिग्निटी सेम है, रिस्पेक्ट सेम है. लेकिन एक पुलिस पर्सनल या ऑफिसर की पावर, जिससे कि वो एक रोड पे बिना देखे समझे किसी को थप्पड़ मार दे, किसी का डिग्निटी डेफिनेटली हार्म होता है. सो इस तरह की चीजें नहीं करने के लिए प्रोबेबली उनकी ट्रेनिंग, उनके जो पावर्स हैं, उनको कहीं ना कहीं रेस्ट्रिक्ट करना बहुत जरूरी है. बिकॉज ड्यूटी ऑफ द पुलिस ऑफिसर इज टू प्रोटेक्ट द राइट्स ऑफ द सोसाइटी. मतलब एक टाइम था जब उनको लोगों के अंदर अपने खिलाफ, अपने लिए डर पैदा करना बहुत जरूरी था. बट वी हैव कम आउट ऑफ इट. नाउ वी आर इन इंडिपेंडेंट इंडिया. नाउ द पुलिस इज here to ensure that our rights are not getting violated. They are the law enforcement agency. तो उनके पास लॉ को एनफोर्स करने का पावर है. एंड जब वो ये करते हैं तो दे हैव टू इंश्योर दैट वो लॉ को इस तरह से इंश्योर करे, एनफोर्स करे कि किसी के ह्यूमन राइट्स जो हैं वो कभी वायलेट ना हो. एंड इफ द पुलिस themselves are doing that, then there cannot be anything more unfortunate than that. So it is important that there are some changes in the criminal CRPC, which obviously the government is looking into. There were many times committees constituted, like the Malimat committee, जिन्होंने कई बार बताया कि किस तरह से rights हमारे compromise हो रहे हैं या violate हो रहे हैं. That is why the rights of accused were given so much importance, so that these kind of crimes, within custody, when a person is in custody, that it should not happen. Anyways, so these were the rights of the accused, and if you have any questions, I'll be happy to take that now.
Yes, ma'am. We have some questions. The first being, both accused in a cognizable and incognizable offense have right to bail or not in both kinds of offenses?
Right to bail is a statutory right. It is a right which has been enshrined, as I said already, that right to bail is an important right which is given under section 50 subclause 2 of CRPC, that any arrested person has the right to get released on bail. So even if it is a cognizable, non-cognizable offense, आपने देखा होगा, even in 376 the accused has the right to अप्लाई फॉर बेल. वो मिलती है नहीं मिलती है वो सर्कमस्टांसेस पे. सो बहुत सारे केसेस में मिली भी है. तो इट इज सर्कमस्टेंशियल, बट it does not, the type of crime does not stop your right to be released on bail. You have the right, you can apply for the bail.
Right. Ma'am, the next question is, what about the rights of 4 persons who were encountered in Hyderabad in a Disha case? They were accused, trial was not even started. So what do you think about it?
See, this case was highly condemned by the legal fraternity, because no matter what happens, everybody should have a right to fair trial. Okay, you cannot say a person is accused till the time आपने उनके evidences नहीं देखे, statements नहीं देखे, कुछ prove नहीं हुआ, आप कैसे चार लोगों को उठा के कह सकते हैं कि नहीं यही लोग हैं जिन्होंने ये किया था. So अगर पुलिस के पास इतनी powers होती कि वो ही evidence देख ले और वो ही इस चीज को judge कर ले, तो courts की जरूरत ही नहीं होती. And the reason why the courts are in place is because this justice system is very well thought of. अगर हम निर्भया के केस में देखें, फॉर एग्जाम्पल आई गिव यू दैट एग्जाम्पल दैट अ लॉट ऑफ पीपल क्रिटिसाइज, अरे निर्भया का केस इतना मीडिया हाईलाइटेड केस था, बट इवन देन इट टुक सो मेनी इयर्स. इट इज बिकॉज आवर कॉन्स्टिट्यूशन ensures that कोई innocent कभी should not be convicted. So if you compare Nirbhaya's case, if you compare Disha's case in Hyderabad, and if you compare Kathua rape case in Jammu and Kashmir, so there were 8 people जिनको guilty मान रहे थे, जिसमें से एक लड़का was not even present there, the one from UP. और बाद में जब एविडेंस और ये सारी चीजें हुई तो ये पता चला कि he was not even present, तो he was acquitted. जस्ट इमेजिन अगर पुलिस ने वहां पे उन 8 के साथ ये किया होता तो एक इनोसेंट पर्सन would have would have been convicted for no mistake of his. What is this? This is violation of human rights. So this is the reason why it is said that justice jaldi nahi hona chahiye, justice sahi hona chahiye. It is not important कि justice बहुत जल्दी मिल गया. It is important कि justice सही मिला. So I personally believe it was completely wrong and it was total abuse of power when it comes to the Hyderabad case, where जो encounter हुआ था, it was completely wrong. Whether it is the UP case, Vikas Dubey ji, late Vikas Dubey. So even that I don't know what it is. Again, it is a subject matter of evidence and proving and trial. But I don't think that police should ever exceed their power in such a way and abuse the power. Hi, I can't hear you. Do you have any other questions? Khyati, I can't see you. I think Khyati is not. Okay, so I'll just see in the chat box if there are any questions. So I see as they are dead, they don't have any rights. What action can be taken against the police who violated their rights? So I think a committee has already been formed who's looking into the Hyderabad case. But as a public spirited individual, if somebody wants to file a case, then yes, we do have a locus to go and file the case against the police action. Because rightly said, Kasab was caught red-handed, but even then he was hanged after trial. So even those 4 people had all the rights to have a free and fair trial, and only after that they should have been convicted if they had committed the crime. How can we take action against policemen when they harass someone on roadside, some vendor or any simple man? Means how can we legally pressurize policemen when they harass a normal man? So as I said, now you must be aware that what are the rights that an accused has. So we as normal people, we are not accused, but then we also have those rights in addition to other rights. So सबसे important Article 14, Article 21, freedom to life and liberty, Article 22, preventive detention. So similarly, you definitely have the right to raise your voice and ask. Raise your voice, I don't mean shout, but talk. So you have the right to speak and ask, even as a normal human being. If there is some harassment which is illegal, so if some vendor is selling something illegally, as in they don't have the permission and they are selling, and the policeman is harassing them, then again you understand that who's on the wrong side of the law. If somebody is on the right side of the law and they are being harassed, you definitely have a locus to raise a question, ask the policeman. And as I said, police has a lot of power under Section 41, and it is very easy for them to say that, you know, अभी उठा के मैं तुमको डालता हूँ जेल में पता चल जाएगा. So that abuse happens. It is very common. But then knowing your rights is the only option. Now that we are in the technological era, so use your technology, use your social media. That is the best we can do till the time you know, the police laws are changed or the CRPC is changed.
Right, ma'am. Ma'am, I'm so sorry for disruptions. The rains today, because of the rains today, the net is coming and going. So I
Yes,
think we are done with the questions, I believe.
I think so. If anybody else has a question.
If anybody, if you want to ask any question on related to any subject or anything, you can ask ma'am. We can unmute you and you can directly have a conversation with ma'am. So I think that is the end of it. So I'll first of all I'll say thank you so much for taking out time today and coming on our webinar. It was such an insightful discussion and we were really privileged to have you. And I would like to thank all the participants for making this webinar successful and request them to give this feedback on the YouTube channel. We are sharing this video on YouTube, so you can just give your feedback in the comment section. That would be really great and appreciated. Thank you so much, everyone.
Thank you guys. Have a nice day.